Welcome to Protecting Your Legacy with Estate Planning.
Hey everybody, welcome to an all-new episode of Protecting Your Legacy with Estate Planning with my buddy Adam Grant. I'm your host, Mike Leon. Adam here is the founding partner over at Stonewood Law PC in Encino, California. He's got a legal experience focusing on estate planning, probate, conservatorship, supplemental needs trust, and a little bit of entertainment law. We're going to get him to explain that in just a second. And he's been helping Southern California families protect what matters most and build this lasting peace of mind for generations to come. In today's episode, we're going to be talking about something that's very important to this process, and that's probate. What is it? How does it work? And how can families in California specifically avoid it? So Adam, good to see you as always. Before we even dive into the topic overall, can you explain what probate is and why it exists?
Yeah, of course. Thanks again for having me, Mike. Happy to be here and nice to see everyone. Probate is a very long and exhaustive process. And I think most of what I try to do is avoid it and teach younger generations to avoid the probate process. But what it is essentially is a tool for the court to make decisions as to what property goes to who if it's not accounted for otherwise. And sometimes it is accounted for otherwise. So we'll get into a will versus a trust. Property that's in a trust does not have to go through probate. So that's kind of the crux of it all. We want to set up a trust, ideally, that houses all of your assets, your home, your CDs, your promissory notes, your intellectual property. If you have a trust that has all of this property, you can have it cleanly and privately go to someone outside of the court purview, outside of the public process. The alternative is that you go through probate. So whatever is not in the trust, say you have a trust and there's one residence in Los Angeles that's outside of that trust, that residence then has to go through probate. And perhaps it's put into the trust through the probate process, but what the probate process looks at is whether there's a will. So that's really the first determining factor. And Mike, I don't know if this goes into our next question, but I can just start talking about how it unfolds in the sense that a will is the dominating document, of course, in any probate. And if there isn't a will, you still have to go through probate, and you do it without a will, seeking one of two things or a few things variously configured, and that's either an executorship or special administrator. And you can be a special administrator with IAEA authority, which gives you independent authorization to do special things. But essentially, you're trying to obtain the authority to make the decisions over the assets that are not in the trust, anything that falls outside of the trust. And so that person who's then nominated by the court, perhaps they have to obtain bond. That's very common in these situations, and we can talk about that as well. But they will have the responsibility of then divvying out the final assets and perhaps doing that with the court purview. But again, it is not a private process. This is going through the court. It's costing you tens of thousands of dollars of legal fees. It's costing you tons of time. So your family, if they have $300,000 or $400,000 estate on the small end, it's possible not much, if any of that, is there when they get through the probate process. So you can preserve all that wealth. You can put it into a trust. You can ensure you never have to go to the court, or it falls through the cracks and you do end up in this probate process.
Yeah. No, I'm glad you explained the process. That was actually my next question. So let me ask you something else then. What are some of the biggest challenges you've seen families face when the estate has to go through the probate process?
Great question. It's almost always money. And it's really tough to talk about this subject, but money divides families, as loving as they are. So what's important about families trying to avoid this situation is understanding the pitfalls, the amount of money that it's going to cost their family, the amount of time they're going to be kept out of the home or out of the various residences that comprise the estate, the professionals that you have to get involved. You don't want to wait months and years. This is a very long process, and it could be avoided. Again, you could plan ahead and use a trust to keep yourself out of probate. That means you keep the legal fees that you would otherwise spend. The time that you would otherwise spend out of the house, you can use the home. These are just simple, easy measures that you can get ahead of. But if you don't, this process is here for the court to otherwise make the determination pursuant to the will, if you've left a will, or if you haven't left a will, they'll have to look at the rest of the estate and the people who are involved, and then make a decision as to either as executor or as special administrator or some other capacity.
Adam, let me ask you, in the state of California specifically, how long does the probate process usually take? And you mentioned about money and costs. What kind of costs are involved?
So there are a lot of challenges in California, particularly the overwhelmed court system, which is another reason you want to avoid probate. It can be a speedy process if there are emergency needs. So you can do things like an ex parte petition. If there's a business, for instance, that needs an immediate decision maker, that's where you can petition for emergency probate. That's not common. And even if it is, it still tends to be a somewhat slow process. At the very big picture, probate's going to take you a long time. That's going to take anywhere from at least 4 to 6 months to a couple of years. That's all time that you don't get to use the properties. You perhaps don't get to use the assets or can't obtain the assets or distribute them to the rightful heirs. So you can avoid all that, put it in a trust, or you can play the system and play your cards, hope that California in a few years will have its stuff together and the court will be more efficient. But absent that efficiency, probate can take a long time and does cost a lot of money.
So, you mentioned something before about privacy and this being public, these probate hearings. Can you kind of explain why sometimes that matters for families, especially ones who value privacy?
Very important to focus on why we have trust. A trust is a private document. You will have a lot of very private details in there. So, for instance, when you have this trust and you open a bank account at Bank of America, for instance, you're not going to take your entire trust. It has your social, it has a lot of private details. You're going to take what's called a certification of trust. So that's just a top sheet summary to these institutions. You keep that document private. If you don't have that trust in place and you have to go through probate, you are going through a very public process where everything is out in the open. Your family members, how much they earn, what assets are in the estate, the infighting that largely happens when money's involved, all of this becomes public. And you don't want your name to come up on searches. You don't want this to be how your name is out there. You can otherwise cut this all off, have this in a trust, and ensure your family's properly cared for. But in the end, if you don't, and you do have to go through probate, it's, again, a timely and costly process that could otherwise be avoided.
Adam, what are some common misconceptions out there about what triggers this going through the probate process? Like, what kind of assets typically cause this? Like, what are some common misconceptions in that lane?
Yeah, a lot of the misconceptions I find are around the will. The will seems to be this very mysterious document, and it does have a high importance, especially if you have a trust that goes along with it. There are a lot of common misconceptions about probate. A lot of them are around whether you need a will or don't need a will. People often think that if they can't find the will, they're SOL, or they can't do anything, they're stuck. With or without a will, you go to probate. And the will expedites things. It appoints the executor. It absolves the executor perhaps of having to obtain bond, which can be cumbersome. So it is important to have that document and give some guidance to the court. Absent a will, you're perhaps seeking or looking at more time in the court system while they navigate the complexities without a will. But what you want to do when this person passes away is you find a will, you look at their assets, try to get a grasp of what they do own, and you bring that to the court. The misconceptions, I think, are largely just around whether you do need this will or can't find a will if you're stuck. And I want to tell people out there, you are not stuck. There are still avenues where you can seek special administrator, an independent authority, or executorship and proceed to carry out the last final wishes of that decedent.
Adam, let me ask you, and I asked you this in the last episode, but can you share an example, maybe it's recent or from afar, something where, proper planning saved a family from going through the stress of probate? And then on the other hand, what happened when the planning was missing?
So I've seen proper planning really save families from having to go to court, and that's exactly what we're trying to do. When we have a trust and everything is in the trust, it can be easily administered outside of the court purview. But when we do have to go to court, families do get stuck. And I've seen families reluctantly have to go that path because they don't have this planning in place. So it's important to get at the ground level. But when it's missing is when you end up in probate. And so sometimes there are tools or avenues you can use to obtain that property that's outside of the trust. It's called a Hexstat or an 850 petition. You can have that transferred to the trust. That is still a court process. That is still in the public domain. And you can still prevent a lot of that if you have the trust in place. But again, I've seen families where they don't have those assets properly put into the trust. That happens, again, commonly where people try to do this on their own. They don't have the hand-holding, and of course, when the person has passed, and they have these deficient documents with a trust and no assets in that trust. it's not a properly set up trust. And so they do end up going to probate, which is exactly what they were trying to avoid.
Adam, for somebody that's listening to this right now, they want to make sure their loved ones don't get stuck in probate court. What's the first step that you would advise them to take?
The first step is really to have a very sincere talk with your loved one and explain the importance of having these documents in place. At the very least, a will, but I think a will and trust, depending on the configuration of your estate. And so it's highly suggested you talk to an attorney, again, preferably someone young who can be there for your family, and adopt some of the thoughts, instructions, desires that you want passed along, and hold those lines as it relates to reflecting your wishes and your kids getting what they deserve, or your grandkids or your family. But ensuring that this loved one knows the importance of avoiding probate, I think, is extremely sincere. You want them to understand that a large portion of their estate, what they intend to go to their family, might never make it there, but that they can otherwise have this estate plan in place to avoid that process, keep what they want going to their family without someone dipping in, taking out legal fees, taking out costs from court. There's a lot of things involved and a lot of time involved. But if you care about this person, you explain the importance of having these documents in place and help them get to the place where they can spend 15, 20 minutes with an attorney like myself, download me on their instructions and how they really want things to work, and then commence a draft of their estate plan. I review that with clients. I ensure their instructions are in place and largely reflective of what they want, so that when something happens to them, they have that peace of mind that their hard-earned assets are going to the people they want to go.
Adam, thank you so much for the time and insights on this, man. We truly appreciate it.
Thank you, Mike. Thanks for having me.
And thank you to everybody out there for listening to another episode of Protecting Your Legacy with Estate Planning. If you'd like to learn more about keeping your family out of probate and building a plan that works, do me a favor right now. Visit stonewoodlaw.com. Be sure to like, subscribe, leave us a review and comment, or share this episode with somebody who needs to hear it. As always, I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.